Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everybody in between. My name is Dan Balkaran, and I will be your employer. There you go. There's my name on the screen. I'm an employment lawyer at Samfiru Tumarkin, LLP, which, of course, is Canada's leading employee-side employment law firm. I am going to be your employment lawyer for the next 30 minutes, answering all questions about all things employment law. So please send those questions in as soon as you can. Let me just see if we've got any in the roster here. As always, just a bit of housekeeping before we get started. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. We've got one question. Two questions, same individual. Can employer promote an employee with less education than me? Yes, of course. The employer do whatever it wants with respect to promoting people that the employer wants to promote due to they think that employee is a star performer. They think that employee is more loyal. Maybe that employee is great friends with someone more senior in the company. They can do that for any reason, and it's not any reason barring a discriminatory ground. So the Human Rights Code enshrines certain grounds under which you can't be discriminated against. So that would be things like your age, race, ethnicity, sexual orientation, gender identity, criminal record, ancestry, family status, disability. There are others. There's a whole bunch of them. And so if, for example, that other individual got promoted ahead of you because that individual was of a different race, very hard to prove, but if race formed at least some part of the decision and it was discriminatory in nature, then no, they can't. Then you have to understand what your relief is, your remedy is in that situation, and your remedy is going to be filing a human rights complaint. And if you want to continue on in your employment with that particular employer and be on a vertical trajectory, filing a human rights complaint against your employer, not really a good way to get there. Now, if in fact there's a sufficient nexus between the discriminatory conduct, or we'll say between the promotion and say the ethnicity or race or whatever the protected ground is of the individual, your damages, so if you were trying to get money, they're relatively small. So generally speaking, probably not worth it. But with all of these things, when you're talking about something that is when you're talking about potentially taking action which can materially affect your well-being is not the right word, affect your relationship with your employer at work, you want to speak to an employment lawyer first, because you don't want to take precipitous action that you can't undo or that a lawyer can't undo later. So again, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Now, bear with me a second. I get all the questions in the queue that I need. So, question, same individual. I was told I was too young for a position. Is this ageism? Is this a human rights violation? It probably is a human rights violation, depending on the situation, right? So if someone says to you, you're too young, you're 18 years old and you're too young to be promoted to a director position, is that discriminatory? I mean, I guess at the strict letter of the Human Rights Code, yeah. But I mean, realistically, director is a position at least historically, held by people in their 40s and 50s and 60s. And so if you're 18 with little experience, I don't think you've got really much there. So it depends on the scenario, right? So again, I mean, if you've got more information, I can assess it for you. Generally speaking, though, age discrimination is the other way. You're too old. You're too old for this position. We're firing you because you're too old. When are you going to retire? You didn't retire soon enough, so we're letting you go. We're demoting you because you're too old. That kind of thing. Too young, generally speaking, no. And realistically, there are many positions that people are too young for. So, but if you're still here on this session, give me the specifics of exactly what you were told, and I'll take a look at it and see if I think it's discrimination. But again, full circle back to what we talked about earlier. Even if it is, your remedies aren't great. They're filing a human rights complaint, and that's going to sour the well if you want to continue to work at your employer. And if you want to get money on the way out the door, generally speaking, human rights damages tend to be small. Okay. Can you explain? Pardon me. Question from John. Can you explain more about Bardell rights? So it's not so much that Bardell is a right. It's that if you are entitled to common law severance, you know what? I think that's really the core of your question, John. So I'm gonna back up a second. So every employee who has been terminated is entitled to notice of termination, or if their termination date is today, to that notice converts into severance, and so they're entitled to severance. It's the amount of severance that matters. Now, the amount of severance, it really flows from your employment contract, but broadly speaking, it can be confined to the statutory minimums under the Employment Standards Act, which is roughly 1 week per year of service to a maximum of 8 weeks, or it can be determined in accordance with the common law. Specifically, it's called reasonable notice, and it's an assessment by the court of how much severance you're entitled to pursuant to a formula. It's really factors, and that's the Bardell, you call Bardell rights, but it's Bardell factors. It's factors from a very old case from the 60s called Bardell, which lists the various factors the court should consider when assessing how much severance a terminated employee should get. And those are, so just to finish off that first part, the determining point of whether you get the small severance, statutory, big severance, common law, is your employment contract. If your employment contract contains enforceable language limiting you to the small severance, then that's what you get. Okay. If it doesn't, then you get the big severance. If you never signed an employment contract, you get the big severance. And the swing is huge. Small severance, 1 week per year to a maximum of 8 weeks. Big severance, 1 month per year. I mean, it's not exactly, but that's the sort of the starting point for the assessment. 1 month per year of service to a maximum of 24 months. You've been there a long time, you're older, you could be looking at 2 years of pay coming to you. So it can be a significant amount. Now, the Bardell factors that you mentioned in determining where the court assesses how much severance you're entitled to are your age, your length of service, your position, and how long you're going to be unemployed for. So, the underlying or overriding policy rationale of employment law is it is effectively full employment. It's the idea that the employer owes a duty to an obligation to the employee to offset to a degree the financial ravages of losing your job. And so the idea is, well, you either provide the employee heads up that they're going to be terminated in the near future and give them time off to look for another job, and hopefully not unemployed for very long, if at all. But if they're terminated today, then the severance money that it converts into is to really cushion their fall, right? To offset the financial ravages of losing your job. And so with that in mind, but it's all about how long are you going to be unemployed? Is the terminated employee going to be unemployed for? And so with the 4 factors, age, the older you are, about 40, 50, more severance you're entitled to, generally speaking. And it starts to get really elevate the older you are. And the reason for that is simple. It's harder to get a job at 55 than it is at 25 or 65 at 25. And law understands that and says, well, it's going to take you longer to get a new job. So we need to give you more cushion. Okay? Same thing with length of service. This is the most important one, generally speaking. I mean, it's an assessment, and there are lots of play in the joints for the court. The court can move the numbers around as justice requires in the circumstances. But starting point 1 year per year, 1 month per year of service. With length of service, the longer you've been in a given location, the more severance you're entitled to, generally speaking. And there's good reason for that, I think. If you've been at a place for 20 years, I've been a hiring manager before. For a long time, I was a hiring manager, and I can tell you that when you look at a resume and someone's been at the same place for 15 years, you automatically think, well, is this person going to have a hard time adapting to a new environment? The opposite is also true. If you see someone on a resume where they've got 6 or 7 or 8 or 9 or 10 6-month or 1 year stops, and they think, well, why has this person not been able to be in a given location for a long period of time? So length of service really does matter, but the same idea, longer you've been in a given location, more severance you're entitled to. And then position, the courts are trying to move away from this, but the assumption is that less skilled jobs are easier to replace and therefore attract less severance, right? So if you're a general laborer, you can get that job fairly easily. You get less severance. However, if you're a CFO, very hard to replace a CFO position, more severance. So it's a bias in favor of supervisors, managers, leadership positions, and then certain segments. So, for example, drivers. There's a lot of the assumption is there are a lot of delivery driver jobs available now. Whether or not the pay is the same as the one that you occupied is a different story, but drivers tend to get less severance. Salespeople, same thing. The assumption is, well, if you sold widgets, now you can sell technology. I don't know if that's a good assumption, but that's there's been a number of legal decisions that talk about that to an extent. So a lot of play in those joints, but that's Bardall rights in a nutshell. It's, does your contract limit you to small severance? No, you get big severance. What's the assessment? Age, length of service, position. And I didn't talk about availability of similar employment, but any money you make in a new job is deducted from what you would have got or what you get from your severance. So if you are making $60,000 a year and lose your job and you have an entitlement to common law severance, and then you get a new job the next day making $60,000, your claim is worth zero, right? Whereas if you're unemployed for 2 years and you're 70 when you lose your job and you've been there for 35 years, you might be able to get two years of severance. So lots of movement and play in those joints. It's a complicated question with complicated assessment and answer. I will say, if you have been terminated, generally, particularly if you've been at the employer for more than a couple of years, you're certainly going to want to talk to an employment lawyer before you sign any release or any document limiting your rights. If your employer terminates you and offers you any money beyond the statutory minimums in exchange for you signing a release, and you sign the release, your claim is over. You could have a great claim to 2 years of severance, and if they offered you 2 weeks of money and you signed that release, you don't have a claim anymore. Okay, so do not sign a release, generally speaking, without talking to a lawyer, without talking to an employment lawyer. And again, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. John, I hope that answered your question. It was a long answer, but it's a very complicated topic. I'm not going to say this person's name because it's a very unique name. I don't want to identify them. My employer is 2 weeks late on paying staff. We haven't received a real explanation why. How long is an employer allowed to be late with paying staff. I don't know the specific answer to that under the Employment Standards Act and what the requirement is, or even if it's even regulated. I will say this, from having been an employer and having been a hiring manager, worked in management for years before I became an employer, I can tell you that nothing sours the well with your employees faster than missing payroll. Employees, generally speaking, will tolerate missing one payroll, but not more, because they have obligations, they have mortgages, dependents, children, all that stuff. And so if your employer is not paying you, and there's, it goes on for a period, certainly you can claim constructive dismissal, and you should. Well, depending on your situation, depends what your employment contract says. Certainly talk to an employer first. I've had clients where the employer just didn't have the money, stopped paying, and then we had to bring an action against the employer for severance and unpaid wages. So, after whatever period of time it is that you're prepared to wait, certainly you want to talk to a lawyer. You have if they're just not paying you, you have an action, or you have a right of constructive dismissal. Whether or not that's financially worth it, you'd have to determine with an employment lawyer. But if you want to stay there and you want to give them the benefit of the doubt, then that's just sort of an amicable conversation you have to have, but with them. But broadly speaking, if your employer is not paying you, or you have concerns about the solvency of the employer, and you have bills to pay, financial obligations, it may be time to look around for something else. Right? I mean, not paying your employees is the central. It's central to the employment relationship. And like I said at the beginning of my answer to this question, employees, generally speaking, will tolerate one payroll delay, accident. But more than that, most of them start to look around and they vote with their feet and they go somewhere else. And if you are someone of longer tenure, or even if you're not, but may have a good constructive dismissal claim, if you're gonna quit anyway and look for something else, well, I mean, generally speaking, you probably want to look for something else, get it, and then quit. But if you don't know when the next payroll is going to come in, you may want to see if an employment lawyer, if it makes sense for you to trigger your constructive dismissal through an employment lawyer, and see what money you can get out of the employer on the way out the door if you've lost all trust in the employer. But I can't stress this enough. If you're going to trigger constructive dismissal, and I know I've said that term a number of times, but haven't explained what it is. It's where the actions of the employer are effectively a termination of your employment. So if your employer stops paying you, that's a removal of a fundamental term of your employment and is tantamount to a termination. So you can trigger your termination. You can claim constructive dismissal, but it is very, very important that you don't do that on your own. Constructive dismissals are hard and they're fraught with risk. Nobody should do that without getting legal advice. So if you're thinking about triggering a constructive dismissal, try to get severance on the way out the door, you need to talk to an employment lawyer first. If you need to reach us, you can do so on the screen, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Really interesting questions today. Just a really interesting mix of different things. Liz asks, after a long medical leave, disability diagnosed, medical note confirms my ability to return to my previous job. Upon my return, new protocols and duties were allotted to my daily work. Sorry, Liz, is that a question? Oh, you felt that too much changed and accommodations were not properly talked about, so you resigned. You got an ROE. All right, so this is what I was talking about earlier. So you don't want to take any actions, precipitous actions like resigning, without talking to a lawyer, because if you want to get money for what occurred, if you've resigned, it makes it much more difficult. Okay? Then the lawyer that you retain has to get around the resignation. Now, resignations are very, very difficult to perfect in certainly in BC, but I think in across Canada, there has to be, if the employee resigned under heightened emotional stress, and it's clear and obvious that that occurred, then the employer has to take steps to follow up with the employee to confirm said resignation. And generally speaking, it's difficult to perfect a resignation, though not impossible. And the longer the amount of time goes by after the employee has resigned, more likely it is a resignation. So, Liz, if you want to see if you can go get money, you should talk to an employment lawyer right away. Now, if you resigned because you were effectively constructively dismissed because you felt that the employer had repudiated its contract of employment with you through these changes, or if they had altered a fundamental term of your employment, it has to be fundamental, then you might have a constructive dismissal claim. You resigned because of the actions of the employer. Those are hard cases. If you lose, you get zero. Okay, so there's a lot of risk. It's not clear because this is just a forum where two-line question comes in, and this is a really complicated situation. But if you had physical restrictions or restrictions generally that required accommodation, the employer has to accommodate you to the point of undue hardship under the human rights code. The code in BC, and it's called different things in different jurisdictions. But if the restrictions went to the core of the duty, so for example, let's just say you were a nanny for babies, but you couldn't lift the baby anymore, is there an element that the contract of employment, the relationship has been frustrated by your medical restrictions, provided that there's some permanency to them? Yeah, maybe, right? Like if you're a nanny and you can't lift a baby, it's kind of central to the duty requirements of that. I've talked to many construction employees whose back injury and their ability to lift has been reduced by 35%, and construction companies said, well, we can't, like, that's part of your job. And then there's a battle over whether or not the employment has been frustrated by the injury. So really complicated, really fact heavy. Medicals come in, so it can be complex. So Liz, other than what I've just said, I will say, because you resigned, you need to talk to an employment lawyer right away, immediately. You want to talk to us, you can do that at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But you need to do it. You resigned already. You need to do it immediately. Like if you need to rescind it, the resignation, because you resigned in a heightened emotional state, that's something they want a lawyer to assess as soon as possible. Okay. JB asks, when is an employer allowed to refuse workplace accommodation? I was injured on the job and now have physical limitations. Okay, so I just answered that question for Liz. The key here for you, JB, is you need to provide consistent and thorough medicals to your employer. So if you have accommodations, make sure it's properly papered, or you require accommodations, make sure that the restrictions and the necessary accommodations you have a doctor's note explaining what they are, and you give it to your employer. If your employer refuses to, so there's a difference between refusing a workplace accommodation and saying, no, just do your job, versus you're not allowed to work here anymore. If we're not going to be able to offer you the job, you may have a termination. Like it may be that you've just been terminated, depending on the question of degree. But because they have to put you back in your job unless you've been, your contract of employment has been frustrated, and that again comes down to, is the nature of the injury central to the duties you perform? So it's complicated jurisdictionally too, because the human rights has a jurisdiction over, and that varies province by province in terms of how this is done. But when it's a disability, it's under human rights jurisdiction. Also, certainly in BC, if you were injured on the job and then the employer is taking problematic action, then you may have a prohibited action complaint through the WorkSafe regime as well. So unfortunately, JB, your matter is it's fact heavy, it's evidence heavy. I certainly can't answer this question fulsomely like you need in this forum. So I strongly recommend, again, just like Liz, it's very similar, you and Liz. I recommend you talk to an employment lawyer. Recommend you do it right away. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Stephen asks, part of my salary is commission-based. Is the employer allowed to change the percentage we make on commission without my agreement? Oh, it's the age-old battle between employers and salespeople who make money based on commission. It is, in my experience, it is always the business's desire to lower the amount of commission salespeople are getting, particularly when they're high-income earners, and it's an ongoing struggle between the two. So it depends. Generally speaking, no, your pay can't just be changed without your agreement, without some sort of. So if your employer wants to lower your pay by 5%, and you don't consent to it, is that a constructive dismissal of your employment? Probably not. It's only 5%. If it wants to lower it by 30%, is that a constructive dismissal? Yes, it probably is, as long as it materializes in the commissions, right? So or at least we have some evidence of it, or projected evidence of it. So it depends on the amount of the reduction. Now, is the ability? No, I'll stick with that answer. I was going to say is commission part of your employment contract, and what does it say about it? I'd want to see that, but I can't imagine the court saying, well, your contract says we can change your pay at any time, so it's not a constructive dismissal. So I think that if it just depends on the specifics, right? If your pay has been lowered by a substantial amount, you've probably been constructively dismissed if you want. And that's the big question, right? So remember what I said throughout this session here. You don't want to ever pull the trigger on a constructive dismissal without talking to a lawyer. They're too hard and the risk is too high. Okay. Now, your remedy in that situation is an unfortunate one. If your pay has been lowered by 30%, your option is to effectively accept it by working under that regime, which happens after about two or 3 months, or after that change, or effectively ending your own employment by claiming you've been constructively dismissed by the pay cut. If you want to stay there, there is no good way of forcing them to not make this unilateral change. If they're trying to get you to sign a new contract with the pay cut, you could refuse to sign it, but just know you're playing with fire a bit, because they may just fire you. Okay, but if you're making $250,000 in commissions and the change means now you're only making $220,000, and the open market, the job market, is going to pay you $120,000, then you probably just want to eat the loss. But so you've got to assess these things across a number of vectors, including what the market will pay you. Do you want to stay there? Do you just want to get money on the way out the door? And I will just caution everybody, when I have clients like this, or I talk to people in this situation where this thing has happened, their first instinct is to make their decision about what they want to do. I'm saying not always, but I've noticed a pattern based on emotion. I'm upset. How dare the employer do this to me? I've been here for 11 years. I've helped to build this company, et cetera, et cetera, et cetera. You should never make a decision with respect to your employment, particularly with respect to your employment entitlements, your ongoing viability of employment in that particular location. Never do it based on emotion. Do it strategically based on what is the best thing for your wallet and your life. Okay, so take a step back, look at it from a 50-foot perspective, talk to a lawyer, and make decide what it is you want, figure out the strategy for what you want, execute the strategy and do it as calmly as possible. Because if you do it based on how you feel purely, you're going to, or quite often, you end up making decisions that can hurt your best interest across time, right? So if you're steaming mad and you feel like doing something precipitously, take a minute, take a couple of days, don't do it. Talk to a lawyer, see what the lawyer has to say, and then reassess once you've had an opportunity to be less upset. Stephen says, regarding my previous comment, why is it that everyone says severance is 1 week per year if this is not accurate? Is this employer spreading misinformation to avoid paying? Well, yes and no. So what I actually said was that there are two severance regimes. One is employment standards. All employers, it's a statute. So it's a law passed by the legislature in Victoria, by the BC government. Every employer has to comply with this. Every employer knows that, and it's 1 week effectively. It's not quite, but it's 1 week per year of service to a maximum of 8 weeks. Employer, when it terminates you, is in the business of paying you as little as possible. So they're going to say, the law says 8 weeks, here's your 8 weeks, because they're hoping you just go away, right? Or here's an 8 weeks plus 2 weeks, sign this release, right? But overlaying that is common law severance, which is, is up to 24 months. It's even higher in Ontario in some cases, but it's generally speaking across Canada, it's up to 24 months. And what determines which one of those two you get, small severance or big severance, is your employment contract. Okay, so are employers trying to not disclose that information to employees so they have to pay you less on the way out the door? Of course they're trying to do that. So listen, Stephen, you I don't know if you've seen our TV programs, but certainly worth the watch. We go into all of that in quite good detail. And you get a lot of information about that. So I recommend that you do watch some of our TV show or TV programs, which are educational around that particular topic. We got 2 questions. I'm hoping we have time to finish them. I hope the moderator is okay with that. Julie says, was let go this past Tuesday without cause. I'm 65, worked for 5.5 years, finished a gradual return to work just the week before because of some medical leave, I imagine, was offered 14 weeks of service. Or severance. Yeah, so that's a little low, but it might be difficult for you to get a lawyer involved because of where the number is. 5.5 years, you're 65 years old. In BC, your sort of your high water mark is probably, I don't know what your wage is, but it's probably around 6 months. In Ontario, it's higher than that. And so you want to do the math on it. But Julie, just like everybody in this situation, particularly your case, because you seem to be fired because of your medical leave or whatever that leave was about. You should talk to an employment lawyer right away. I'll say this right now, and I won't do it at the end. If you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Last question from Fred. Can employer freeze my RRSP contribution and their contribution from moving to another institution till my severance case is settled with them? Well, generally speaking, RRSPs are managed by third-party providers, like a bank or an insurance company. Okay, so the money's not being held by your company, or at least it shouldn't be. So you want to look into that. If it's being held by your company, which I've never seen before, yeah, I imagine they're going to want to use that as leverage over you. Can they do it? No, but I mean, your recourse is the courts, and it'll get worked out before there's any penalty anyway. So, but freezing your contribution, well, if you've been terminated, that contribution is probably over anyway, and that's something you're going to haggle about, right? So what I would do if I were you, Fred, is I would double check who's actually got your RRSP contribution money. I suspect it's not your employer. I suspect it is a third party like a bank. Okay, listen, we're way over time. Great questions, everyone. Have a great weekend, wonderful and safe weekend. Hope you enjoyed today's session. Please let us know if you did, and join us next week for Chris Justice, Monday, 29th, 1:30 p.m. Eastern Time. He's going to be answering your questions about all things employment law. Other than that, have a wonderful and safe weekend.